Are Canadian constitutional rights only for the elite? Then why are courts preventing self-represented litigants from access to justice? SRLs make up the majority of Canadian litigants today due to the unaffordability of hiring a lawyer. Why would courts be using baseless labels like vexatious due to their unfamiliarity with the court environment to disadvantage them? The term literally means to intentionally harass or annoy. How does being unfamiliar with something translate to that? Courts have even gone to the extent of saying if you use the wrong semantics or formatting or take too many pages to explain yourself, that somehow that makes you intentionally harassing or annoying. Now, anybody who's new to a particular court process, wouldn't that be normal things for them to make mistakes in? The vexatious label was specifically meant to be used for cases that don't have any merit, where there's not a real dispute amongst people. But courts are using these other things that have nothing to do with the merits of your case to prevent you access to justice. The vexatious label was used on me after I refused to put out for Judge Thomas John McEwen and spoke out about it. Retaliation for anyone speaking out about sexual harassment from judges and lawyers in this justice system is something that's very common and feared by a lot of women. This is why there's such an exodus of female lawyers exiting the system. No woman or Canadian should have to sleep with a judge to get their basic rights or to access justice. To access some of the articles I found on this subject, click on the link. It's just below.